As we have a recent change of the timetable on the preliminary injunction regarding the Reyes case, regarding the preliminary injunction and dates, I thought we'd just mention that, but I never went through Mark Stout's amicus curiae brief in support of the City of New York regarding this case. Now, if you remember Mark Stout, he once was an auditor and is now anti-auditor, and he submitted this brief in support of the City of New York. I bet they're grateful for it. Anyhow, let's have a look. Don't need to look through the table of contents. Right. The amicus curiae is Mark Joseph Stout, an individual. Stout has a YouTube channel, Frauditors Exposed, that features unflattering live streams and videos about individuals who enter onto government building property to film in purposeful violation of building policy, prohibiting or restricting filming individuals professing to be sovereign citizens and First Amendment auditors. Stout shares information with government agencies and employees about the public forum doctrine, and that clearly establishes that government building properties, including police station properties, are non-public forums, that individuals do not have a right to film in non-public forums, and that policies and ordinances prohibiting or restricting filming in non-public forums are reasonable. Stout has submitted legal memorandums to prosecutors and city councils. Prosecutors have submitted Stout's legal memorandums to the courts to convict sovereign citizens, bleak First Amendment auditors. Sheridan, Colorado, and Easley, South Carolina city councils adopted Stout's legal memorandums as a source of authority to enact ordinances declaring government building properties non-public forums and prohibiting filming therein. Stout has successfully litigated many pro se civil rights cases, filming cases that produce case law in Stout's favour before settling. Stout, a retired street activist, has an interest in furthering and advancing the right to record police activity in traditional public forums, streets, sidewalks, plazas and parks, and an interest in demonstrating that individuals who enter onto government building property to film in purposeful violation of building policy, prohibiting or restricting filming, are nothing more than common criminals engaging in wiretapping, harassment, stalking, trespassing, and other crimes to manufacture content for YouTube videos. The outcome of this case determines whether or not NYPD's police precinct lobbies are non-public forums and whether or not individuals have a right to film in non-public forums. If this court rules that individuals have the right to film in NYPD's police precinct lobbies, individuals who already film police activity in traditional public forums will gravitate away from that risk and towards filming unsuspecting administrative, technical and clerical workers because it's much easier and safer to make government staff employees uncomfortable for YouTube content than it is to find and film police activity for a cause. If this court rules that individuals have the right to record in NYPD's police precinct lobbies, individuals who decided that filming police activity in traditional public forums was too risky, or individuals who were previously undecided, will now decide to film government staff employees in police stations and other government buildings because filming government staff employees is the path of least resistance and the employees are low-hanging fruit. Stout's source of authority to file is Federal Rule of Appellant Procedure, Rule 29(a)(2), Rule 29(a)(4)(e) statement. An attorney did not author this amicus curiae brief in whole or in part. Stout, an individual and non-attorney, authored this amicus curiae brief in whole. Stout did not contribute money that was intended to fund the preparation or submission of this brief. Neither person contributed money that was intended to fund the preparation or submission of this brief. 7. Argument. NYPD's precinct lobbies are not designated public forums, but non-public forums. Individuals do not have a right to film in non-public forums. Sorry, I don't remember doing 1 through 6. Oh, yeah. So 1, 2, 3, 4. We don't have a 5. We don't have a 5. There is no 5. Okay. Rare's attorney contends that at the very least, these NYPD police precinct lobbies are designated public forums, places that have been opened to the public specifically for a public purpose. In Stout v. Michaud, and there's a reference, the court ruled that plaintiff's characterization of the police station sidewalk as a public sidewalk that was designated for public access constitutes a legal conclusion that need not be accepted. It is not clear that the sidewalk area just outside of the security gate of the police parking lot at the police station is a place which by long tradition or by government fiat has been devoted to assembly and debate. The rights of the state to limit expressive activity are sharply circumscribed. Further references. If individuals do not have a right to film from a police station's outdoor sidewalk, then they certainly do not have a right to film from the police station's indoor lobby. Raya's attorney contends that NYPD police precinct lobbies share little with government waiting rooms that have been found to be non-public forums, i.e., interior rooms designated for appointments. The NYPD is a government agency and NYPD precinct lobbies are waiting areas. Therefore, NYPD police station lobbies share everything in common with and are non-public forums. Raya's attorney contends that, and there's references, Glick v. Cunny, Fields v. City of Philadelphia, Turner v. Driver, ACLU v. Alvarez, Fordyce v. City of Seattle, and Smith v. Cumming, established that recording the police is protected First Amendment activity. While the Second Circuit has not yet been presented with this question, other circuits have uniformly held that the First Amendment encompasses recording the police, and none thinks the question is close. The cases cited by Raya's attorney establish that individuals have a right to record police officers and police activity in public, not in non-public or limited public. There are four publics: traditional public, designated public, limited public, and non-public. Public is short for and interchangeable with traditional public. Furthermore, the plaintiffs to all of the cases cited by Raya's attorney were filming from a traditional public forum, a street, sidewalk, plaza, or park. The cases cited by Raya's attorney do not establish that individuals have the right to film wherever there are police officers or there is police activity, but that where individuals have the right to film police officers and police activity in traditional public forums, police officers may not invoke their governmental status or the nature of the police activity to prohibit individuals from filming. Raya's attorney contends that New York State's and New York City's Right to Record Acts state that a person not under arrest or in the custody of law enforcement official has the right to record law enforcement activity. However, New York State's Right to Record Act further states that nothing in this subdivision shall be construed to permit a person to engage in actions that physically interfere with law enforcement activity or otherwise constitute a crime defined in the penal law involving obstructing governmental administration. And New York City's Right to Record Act further states that nothing in this chapter shall be construed to permit a person to engage in actions that physically interfere with an official and lawful police function, or to prohibit any officer from enforcing any other provision of law, including provisions of trespassing and obstructing laws. 8. Certificate of Compliance. Stout certifies that this document complies with the Federal Rules of Appellate Procedure, Rule 32(3)(1), and that this document is 1,407 words, and it's signed by Mark Stout. Right, I hope you enjoyed that. I'm still wondering what happened to number 5. 1, 2, 3, 4, and then 6. Oh well. Let's have a look at where we are with the case. So this was a minute entry for proceedings held before Judge Justice G.L. Clark. Status conference held via Microsoft Teams on 22nd August 2023. Counsel Mina Oberdick and Andrew C. Case present for the plaintiff. Counsel Gregory Musso present for the defendant. Opposition to plaintiff's motion for a preliminary injunction to be filed by September 1, 2023. Reply to defendant's opposition to plaintiff's motion for preliminary injunction to be filed by September 15, 2023. The order is to show cause hearing is hereby rescheduled to September 28, 2023 at 10 a.m. So that's the next hearing on the injunction. I'm not sure that the defendants will get any further extension of time. Thanks for watching.